Hi, my name is Vivian Solomon, and I'm going to be taking you on a stroll through the rules of professional conduct. This is a presentation that has been certified for 1 hour of ethics credit by the Oregon State Bar for Oregon attorneys seeking ethics credit. I assume you are here because you need to have the ethics credit for your reporting period, and if you wait till the end of this presentation, you'll earn that hour. Something that you can find on the website are the high quality written materials which come along with this presentation. They look like this, and it's 19 pages. You may or may not want to print that, but it's available to you. I will be referring to cases cited in these materials as I go through the presentation, so you will want them at some point. The website also tells you how to get the credit. You will need to download a form from the Oregon State Bar, an MCLE form for recording purposes. The website tells you the program number for this program, so it should be pretty easy for you to submit a self-screening hour of ethics credit. So let's begin with why are there some of these rules. Some of them seem really obvious, but I will tell you that there is a story behind each one, and we'll be talking about those for the next hour or so. I have given you background on the Oregon Rules of Professional Conduct in case you need to cite these for any purpose. Oregon initially adopted the ABA model rules in 1971, and we knew them as disciplinary rules. And Oregon did not adopt any of the ABA rules until 2002, at which point Oregon switched from the disciplinary rules to the rules of professional conduct. But Oregon did not adopt the commentary that goes with the 2005 rules. So if you are doing research on this subject, please look at the written materials. I have given you links to other publications. I give you research tips, and putting all this together, either you will find something that you can use that's from Oregon, or if not, you'll be able to cite to the model code and use that to support your argument. I will be discussing a few cases that are not in the written materials today. If you need a citation or a copy of something I mention, please email me. My email address is vivian@viviansolomon.com, and I will email back to you the citation or the written materials or anything else that I've talked about that you'd like a copy of. So next we're going to move into the Oregon Code of Judicial Conduct. I'm going to touch on this briefly because some of you may be interested in running for office, you may be judges, or you may be lawyers who are volunteering your time as pro tem judges. Thank you to those of you who do that. It's really helpful in moving cases through our court system. So most of us are lawyers who will appear before judges, and so while the Code of Judicial Conduct does not apply to us directly, it might be necessary if you are seeking to disqualify a judge or if you need to be reporting improper conduct. Disqualification usually comes about because there is a conflict between the judge and a party, or the judge and the subject matter of the case. Or disqualification can also come about if you believe the judge cannot be impartial or fair for some reason having to do either with the background between the judge and a lawyer, or the judge and a party, or the judge and the subject matter of the lawsuit. And then there's some improper conduct examples I've cited. There's a trio of cases that I want to tell you about to show you the kind of improper judicial conduct which has been sanctioned. The first is In re Ochoa. There, the judge belittled defense counsel in the presence of the jury. When the jury returned a verdict for the plaintiff, There was a complaint, and the judge was found to have acted not impartially. The next, in re Lemery, the judge was a pro tem judge who, I'm sure meaning well, during a break decided to discuss the case with one of the parties, also not impartial. And I think my favorite of the triumvirate is in re Baker, where the judge was out on the town and saw in the bar or the bar of the restaurant someone who had appeared before her on a DUI. She ordered him out of the bar and ordered him to appear in her courtroom the next day for a contempt proceeding. He showed up, and then she used some swear words. All of these were multiple issues of improper conduct by the judge. So hopefully you will not run into judges like this. Most of our judges are really great, upstanding, impartial arbitrators. So moving on to the Oregon Rules of Professional Conduct. Sometimes I see that and I think it's a typo for ORCP, the Oregon Rules of Civil Procedure, but it's the ORPC. It has 8 parts, starting with the client-lawyer relationship, and that is the only part that we will be covering today in this presentation. I will be preparing a subsequent video or 2 on the remaining 7 parts, but there is enough information about the client-lawyer relationship to fill the rest of this time. So the other 7 parts are listed on that slide: counselor, advocate, and so on. But we are going to begin by talking about the client-lawyer relationship. All of us are lawyers, and all of us have clients, otherwise we wouldn't be lawyers for very long. There's a lot to talk about here. The first rule, 1.1, is competence. Most of us interact with competent lawyers, even though we might be handling tens or dozens or even hundreds of cases at the same time. We can act in a competent manner. There are, however, those among us who are not competent. I have served on the local professional responsibility committee, and I saw some examples of that. Glad to say I've never run across anyone like that in my practice, and hope you haven't either. Competence is defined as legal knowledge, skill, thoroughness, and preparation. Now, this is a fact-specific designation, and as we serve our clients, the standard is objective. It's not what we think, how well we think we're doing. It is whether a reasonable person would think that we have the legal knowledge to work on this case, that we have the skill to apply that legal knowledge, that we have been thorough in our preparation, and that we have prepared at all. Sometimes that is the case. So it is more than a poor result. Just a bad outcome does not mean you were not competent. Let me give you a couple of examples of incompetence. The first is in re Speece, that's 316 Oregon 530. A land use lawyer was handling a divorce, and he was found incompetent for representing a client, or she was found incompetent for representing a client in a matter outside her area of expertise without acquiring adequate knowledge or skill. Second, in re Oddman, 297 Oregon 744, the accused was found incompetent where the facts showed improper and late filing of estate documents. I quote, "The accused did not know basic steps in administering and closing decedent's insolvent estate." And third, in re Chambers, 292 Oregon 670, the accused was found guilty of incompetent representation where the record showed that the accused tried a criminal case by the seat of his pants. So these are 3 examples where the attorneys did not have the knowledge in the area in which they practiced. They didn't have the skill. They maybe didn't prepare, especially the one who tried the case by the seat of his pants. So although most of us interact with competent lawyers, sometimes we run across those who are not. And here's a very interesting question. What about pro bono cases? We are all encouraged to do pro bono work, and I think that's great. We need to do more pro bono work to help those people who are unable to afford legal services. But at the same time, we have to be careful as lawyers that we are competent in providing that representation. There's a decision from the Third Circuit specifically on this point. It's the Ashcroft case, 259 F. 3rd 127. An immigration lawyer, a lawyer who was not an immigration lawyer, failed to file a document, and the court wrote that an attorney's obligation to his client is not diminished by the pro bono nature of the representation. So the court continues, because all clients deserve the same level of basic competency from their attorneys, we are unwilling to endorse a lower standard for pro bono representation. So what does this mean for you? It means that you should do pro bono work, but if you are helping someone outside your area of expertise, whether that be divorce or criminal or landlord-tenant, make sure that you get someone to help you, or only take cases in your area of expertise, because you can be found to have violated the competence rule by not doing a good job in a pro bono case. So let's move on to the next subject, scope of representation and allocation of authority. This is Rule 1.2. We all know that we cannot be hired against our will. We can say no at the outset before we form an attorney-client relationship. But many of us don't know that there is something less than full-blown representation, and it is called limited representation. This is a really good thing to do if you are helping the cousin of a friend with just a little thing, like maybe just reading a letter or writing a letter without knowing the full nature of the dispute. If you're going to do that, please do it with limited representation. This requires counseling the client about the pros and cons of the limited representation. It means that you're not looking at other things, and that means you might get things wrong, or you might not tell your client everything because you don't know everything. The upside is it might cost less and it might be quicker. That's not always a good thing. You sometimes get what you pay for. There is a New Jersey decision, Lerner versus Laufer, 359 New Jersey Super 201, a divorce case where the attorney agreed to limit the scope of his representation to a review of the terms of a mediated agreement. He did consult with the client, and he had this limited representation agreement in writing, and the court found that he had not violated his ethical rules, even though things did not go the way the client said they should have. And the reason is because they had an agreement for a limited representation. So if you're going to do a quick job, make sure it's with limited representation. Otherwise, this 1.2 rule, scope of representation, often comes up in the settlement context. Lawyers have to defer to the client. It's the client's case. The client gets to decide whether to settle or whether to go to trial, whether to settle for X amount or Y amount that you give your input. The client is paying you for your input, but ultimately it is the client's decision. Similarly, you can't take actions that are not authorized, and this includes making sure the client has authorized you to take the step, like to settle the case. You cannot settle a case without having your client's authority to settle. Otherwise, you're in big trouble. So only take the actions that are authorized or impliedly authorized, and don't abandon your client. We'll be talking a little bit later about how the right way to terminate a case, and if you try to terminate your representation by just walking away, you will be violating one or more rules of professional conduct. What about pro bono? How does this work in the pro bono case? It's exactly the same. The same rules apply in pro bono as they do in a situation where you have a client who is paying a fee. Next, we're going to be talking about diligence. This is Rule 1.3, and it is a one-sentence rule. a lawyer shall not neglect a legal matter entrusted to the lawyer. This is an Oregon-specific rule, and you can take heart that the definition of neglect here is different from making a mistake. We all make mistakes. That does not mean we are neglecting a legal matter. When you are neglecting, it has to be a course of conduct. It has to be the failure to act or the failure to act diligently. It is not just forgetting to do something or doing something wrong once. An isolated incident of negligence is not a rule violation. In a case in Ray Koch, 345 Oregon 444, the accused was found to violate this rule where she did a couple of things in a row in a case. She didn't tell her client that the client had to contact her soon-to-be ex-husband to prepare a divorce document. She didn't answer her client's questions, and she didn't help her clients correct a judgment. This was seen to be a course of conduct, not an isolated matter, and she was found to have violated the rule against neglecting a legal matter. So, unless you are a Led Zeppelin fan, you don't want to have a communication breakdown. Communication is Rule 1.4, and we are required to keep our clients reasonably informed. Again, it's the client's case. We lawyers get wrapped up in working with each other, working with judges, working with arbitrators, working with mediators, experts, and it's kind of like those old-fashioned cameras where the hood is over the head and you're looking through narrowly at what's in front of you. The director is behind you, and you have to take that hood off and talk to the director, and the director is the client. You have to communicate with the client about what is going on. Especially, you have to communicate bad information. Just because it's bad doesn't mean it's going to go away if you don't talk about it. It'll just get worse. Also, you can tell the client that the client's claim lacks merit. You can say, I don't think this is going to work, or at some point you have to say, I cannot sign a pleading because I don't think this claim has merit. But you need to talk about this. You can't let the client assume you're doing one thing when in fact you're doing something else. The court in Ray Snyder confirmed that it is more than bad customer relations. We've all had that experience where we go into a store, and maybe we talk to a clerk who's having a bad day, and the clerk doesn't treat us well, and we don't have a good experience, but ultimately we get the product we came to get. Well, the same thing with legal matter. If the client doesn't like the way you talk to them, that is not a violation of the communication rule. That said, do what you can to let the client know when you're not available. If you're in trial, put an out-of-office email reply. If you have an assistant, forward your phone to the assistant. Check your voicemails when you can, or have your assistant check the voicemails and the emails and reply with a generic message that says the attorney is in trial and we'll get back to you as soon as possible. So the client doesn't feel like they are being ignored. That is a big deal. Clients don't like being ignored. So what happens when you have a client who pesters you daily, is sending you email after email or phoning you repeatedly with questions? Do you have to answer all those questions? The good news, the answer is no. You have to provide the client with enough information for the client to reasonably be able to make an informed decision about what is going on in the lawsuit and how to proceed. If you are getting a lot of emails, I suggest you batch them together and answer them rather than answering them one at a time, or it'll suck up all your time. You won't be able to work on your other files. And similarly, if you have messages left on voicemail and you know you're going to get more than one, it's okay to wait to listen to several of them and then respond once. You might want to have a paper trail now that we all have so much email in our files. You may even want to respond to the voicemail messages by email, but the bottom line is you do need to communicate. What about the difference in client sophistication? You need to tailor your communication to the client. If you represent a corporation and you are talking to in-house counsel about depositions, you don't have to explain what depositions are. You can just move on to the meat of the story. But if you are representing an individual who does not know what a deposition is and is scheduled to give a deposition, you need to communicate a lot about what goes on in a deposition and why it's important and how it could be used at trial. So again, you need to tailor all the communications in the case to the client. Otherwise, client, for example, may show up in deposition, not know what to do, say things that he made up, or whatever, and that will not work well as you move down toward trial. So give the clients the information necessary to make the decisions. Let's talk about fees. This is Rule 1.5. Fees cannot be clearly excessive. And although the courts don't like to poke around too much into fee agreements, they do look at agreements at 2 points. The first is when you enter into the agreement with the client, and the second is when you collect the fees. So if you start a case, get a fee agreement, agree, let's say, on a contingent fee, I know that's the last thing, but I'm going to talk about it now, a contingent fee agreement, and then the case settles, maybe in a week or two, is it fair for you to collect the entire contingent fee on a very large recovery? That was the question that was posed in a case that is not cited in your materials. It's In Re Goff. I have that citation here, and I will give it to you. That's exactly what happened in that case. It settled within a week or so of filing for $3.2 million, and the client sued, claiming that the contingent fee was excessive. The citation is 126 or App 194. The court did not get to the substance of the dispute. Mr. Goff was also has a Supreme Court case, In Re Goff, in which the claim was also dismissed. So we have no guidance from the court, but we do know that this issue has been raised by an Oregon plaintiff, claiming that his attorney's fees were excessive at the time of collection. So if this happens to you and you are fortunate enough to not have to do very much work and stand to collect a huge fee, you may want to reconsider what that makes your hourly rate. And if it's $100,000 or so, you probably should reduce your hourly rate and reduce the collection. So what about unearned fees and substantial steps? If you take a retainer, you need to work for it. There are 2 cases cited in your materials, In Re Balaka and In Re Obert. In the case of In Re Balaka, the court said that substantial steps to perform the work must be taken before the fee can be collected. And in the Obert case, the court held that simply meeting the client is not a substantial step. You actually have to do some legal work to earn your fees. Confidentiality is one of the earliest rules on the books. It is the ethical counterpart to Oregon Evidence Code 503, the attorney-client privilege, and it is also in the Oregon statutes at ORS 9.460 under duties of attorneys. It was one of the very first rules on the books. It was in Deede's Code in 1865. Okay, let's digress for a moment into Oregon history. Who was Deedy? We've all heard of Deedy's Code in law school, right? So Matthew Paul Deedy was on the Oregon Supreme Court from 1853 to 1859, at which point he was appointed the very first judge of the federal court, the United States District Court for the District of Oregon. And he served as the only judge on the Oregon federal bench until he passed away in 1893. And of his decisions, we know probably best the Pennoyer versus Neff case, which was argued in the Supreme Court and eventually overturned. But anyway, back to confidentiality. It is one of the earliest rules on the books, and the rule as it applies in the ethics context to attorneys is reasonableness. We have to make a reasonable effort to prevent disclosure. Again, perfection is not required, but reasonable effort is required. It is a very broad protection. It covers all attorney-client information, which means that it shows up in a lot of different places, and I'll talk to you about some of those now. First, we have electronic data, and although there are some lawyers who wish they had retired before they ever heard of electronic data, it is a fact of life, and I do give you a research tip for a CLE from the Professional Liability Fund, saying that we need to have a basic understanding of e-communication as part of our job as lawyers who handle cases that go to trial in particular. I had the fortune to attend a CLE in the state of Washington presented by James Yand, Y-A-N-D. He's a partner at Miller Nash in Seattle, on the subject of inadvertent disclosure of electronic information. And Mr. Yand graciously said that I could share those written materials with you. You just need to email me, Vivian@viviansolomon.com, and ask for it, and I will share those with you. It's worthy of half an hour of discussion on its own, and this is a stroll through the rules, so we're not going to dive that deeply into this particular rule. So let's go back to some other places where there might be confidential information. Recycling office paper. You need to make sure that all of those pages that have confidential information are shredded or otherwise destroyed in a way that they cannot be read by those who shouldn't be reading them. And we see these shredding trucks downtown, and that's a really good service, but you need to make sure that whether it's a shredding truck or going to PostalNet and watching them put it into a recycling bin with a lock on it, that you know what steps the company you've hired is taking to protect the confidentiality of those documents, because you are ultimately responsible for confidentiality, so you need to know that those people are following the rules the way you would like to have them followed. Client data can also be found in your notarial journals. Sometimes just the fact that somebody was in your office is confidential information. Let's say you are a divorce attorney and somebody's signing a notarial journal and sees somebody else's name there. They might draw the conclusion that that person might be getting a divorce. Whether that's true or not, it's certainly not the kind of information your other client would want the general public to know. So I think a lot of people who are using notarial journals now cover up the information above the line that is being signed. If they're not doing that, they should, because you only want to be able to see the line on which you are signing. What about reading confidential documents on public transportation? Legal assistants who are annotating medical records, for example, on the MAX or the bus, or heaven forbid they're dictating, or even lawyers or assistants who are working on laptops, either on the bus or on an airplane. You know, you're on a plane for hours and you're working, and maybe the person next to you thinks that your stuff is more interesting than what they have to look at. I do have a suggestion for the latter. there is a product that you can use that it goes over your screen and it only allows a straight-on view. So views from the side do not see what's on the screen. It's kind of like some of those stoplights where you can only see the direction in which you're coming, so you don't get confused at a five-way intersection. If you can't find one on your own, email me and I will tell you the results of my search on that subject. How long does confidentiality last? How long is this relationship supposed to continue? Well, it continues after the attorney, even after the attorney-client relationship terminates. I have cases from Wisconsin and California that say the duty to protect confidential information continues even after the formal relationship ends. So it continues even when you're seeking to withdraw from representation. You need to maintain the confidentiality of your client's documents. And we do know that there are limited circumstances when client information can be revealed, the crime exception and the fraud exception. We read those in law school and to prepare for the bar exam, and I'm not going to go into those in any depth here, but if you need if that subject comes up for you, I'm sure there are plenty of materials you can find on it. I'm going to move on to conflicts. There are many rules on conflicts of interest. We are going to start with current clients. Current client conflicts are not allowed. What is a conflict? Well, let's just say you cannot take a case if there is a significant risk that your personal interest will limit the representation. Now, what does that mean? That means I have this client, but I could also take this client and get paid twice as much, even though taking this client means this client will not do so well. That's putting your own interests, more money from this client, ahead of this client's interests, which are to do well. So you need to tell your clients everything they need to know to make an informed decision. Issue conflicts, we don't anymore talk about issue conflicts. This was a term used under the disciplinary rules, but it is still something that comes up in Oregon analysis. It's usually okay to have an issue conflict, and that means taking two different sides on the same issue. But there is an Oregon ethics opinion which says you cannot have an issue conflict in the Court of Appeals. You cannot be an appellate lawyer arguing for and against the same issue at the appellate level. The current client conflict can come up in the corporate context. Unlikely, but if you represent a corporation whose in-house counsel has a conflict with the corporation, the in-house counsel needs to hire outside counsel rather than do that representation herself. Let's go on to special rules for current clients, and I'm just going to tell you what page I'm on here in the written materials in case you want to be following along. We are on page 9. So I cite there the in re conduct of Spencer. The first part of the rule prohibits lawyers from doing business with their clients unless the clients have consulted with another lawyer first. In Spencer, the lawyer violated Rule 1.8a when he entered into a business transaction with a client without advising her to seek independent legal advice and giving her the opportunity to do so. So the first current client special rule is don't do business with your clients unless they first consult with another attorney. Don't buy or sell real estate from them. Don't enter into loan agreements with them. As the slide says, don't knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to your client. You can deal with your client in the same way that everyone else deals with them. For example, if your client is a bank, You can have a bank account at the bank. You can have a loan from the bank because that's the bank's business and it's available to everybody else. What you cannot do is have that kind of relationship with an individual who isn't in the business of making loans. And in the In re Schenck case cited in your materials, the court set the standard as conscious awareness of essential facts. In that case, the lawyer entered into a loan agreement with his client, but said he didn't think that she was his client at the time that happened. The fact finder disagreed. Another current client special rule has to do with joint representation, and the short answer is that when you have joint representation, you need to keep all of the clients equally well informed about what is going on. And that was the In re Conduct of Gaddy case, where the claim was that the lawyer failed to explain matters to the extent necessary for informed decision making. Okay, I am guessing that just about everyone watching this ethics CLE has either left a law firm or had another lawyer leave his or her law firm. When that happens, there is a potential for conflict because there is a former client situation. So change means a potential for conflict. What are your duties to former clients? This is Rule 1.9. This often hits home for contract attorneys as well as for lawyers who leave to form their own firms. Anyone who is left behind is a former client, but also anyone you take with you becomes a former client for the law firm you used to work for. There are ethics opinions on this. You have, well, you should know that it's matter specific. The court will look at the facts of the specific instance. You can take a matter, you can take a case adverse to a former client if there's no matter specific conflict. For example, let's say you represented a client in your old firm on a land use matter, and now you are being asked to sue that client in a car accident matter. There should be no matter-specific conflict between those two situations, but that doesn't end the inquiry. You cannot act adversely to a former client on a matter that is the same or substantially related, that's the same transaction or legal dispute, or if there would be a substantial risk of confidential information that would materially advance one client's position against the other. So let's say in representing the land use client, you learn something that becomes important in the car accident case, like the existence of assets maybe. That would be a substantial risk of confidential information being disclosed and would not allow you to have that adverse relationship. That would be a conflict. There are some times when a written consent will waive that conflict if you have confidential information on a different matter. And that's Ethics Opinion 2005-17. And I'm going to read it because I think it tells you exactly what you need to know. If material confidential information that could be used adversely to the former client was obtained, informed consent from both the current and former clients would be necessary. To be effective, the informed consent must be confirmed in writing and would have to include a discussion of the potential for adverse use of the confidential information and the possible effect of that use on the former client. This ethics opinion cites to an earlier ethics opinion and also cites to the former rule of professional conduct. So if this comes up, look in the research tips and you'll find some information about written consents. I believe that the Professional Liability Fund also has forms on its website for conflict situations. Yes, I've also suggested the Oregon CLE, the Ethical Oregon Lawyer, Chapter 9. You can get that through going to the Oregon State Bar website and going into Bar Books. Still continuing with conflicts of interest, screening. Screening applies to when lawyers change firms, whether they apply to lawyers coming into new firms, and they apply to the firm that the lawyer has left. A firewall in the old firm will allow for the for having an adverse relationship with a departing client. Associated lawyers, those are of counsel type relationship, have to abide by this rule. An associated lawyer cannot represent a client that lawyers in the firm could not represent. That is different from office sharing. I'll be talking about office sharing a little bit further later on today, but an associated lawyer is deemed part of the firm for the purpose of conflicts of interest. And there are special conflict rules when the government is involved. My guess is that not too many of us here are working for the government, but some are. And what I thought was interesting are that the rules are different. If you leave a government job to work in the private sector, disqualification is imputed to the private firm unless there's some kind of firewall erected around you coming in from the government job. But if you turn it the other way and you leave, say, your law firm to go work for the DA's office, disqualification is not imputed to the DA's office or other government attorneys. So it's kind of a one-way street when it comes to the government. This is another head-scratcher rule. Why do we need to have a rule that says that former judges, arbitrators, mediators, or other third-party neutrals can't represent people or entities that have been before them? Well, because people have done that, and I have cited to In Re Zafforatos, which is a case about a lawyer who was disciplined for bringing a civil action for property damage arising out of a motor vehicle collision when he acted as a part-time municipal judge in a related proceeding. So whether you are a pro tem judge or some other kind of neutral, if somebody has appeared before you, you may not represent them in the same or related proceeding. Now, what about representing an organization? I talked about this a little earlier. When you have a company, you need to distinguish the corporation from its employees. If you are representing the corporation, you are not necessarily representing the employees. A lawyer can represent the corporation and its employees, but not always. Let's assume that there's litigation and the corporation wants an employee to give a deposition, but it's not in the employee's best interests. In fact, maybe the employee should claim the Fifth Amendment privilege against testifying. That's a pretty obvious example where one lawyer could not represent the corporation and that employee because their interests are not the same. So identify the client is the corporation. Separate counsel would need to be obtained for that employee for that purpose. If the employee and the corporation have the same interests, then there isn't a problem. Now, how to deal with the client's officers, directors, and employees. You need to understand that they are not the corporation, and if they are about to violate a law or make the company violate a law, your responsibility is to the organization, and you need to tell someone higher up that you think this is going on, because the someone else higher up who's representing the organization is your client, not the individual officer, director, shareholder, or employee who is trying to make the company or do something in the company's name that violates a law. Consent is important when representing an organization. It's similar to knowing that a party with whom you are contracting has authority to sign the contract. When you are representing a corporation and acting in the corporation's name, you need to make sure that the person giving you consent has authority to give you consent. Otherwise, if you are acting on behalf of the corporation without consent of the party, you will be violating some of those rules we talked about earlier that said you can only act within the scope of your representation and within your authorization or implied authorization. So if you haven't been authorized by the corporation and you act, not good. Let's move on to Rule 1.14, an impaired client. If you are representing a client with diminished capacity, you are to maintain a normal client-lawyer relationship whenever possible. But if you notice that the client is not able to act in his or her best interest, or is not able to follow the reasoning necessary to make an informed decision, this is one of those few times when you are allowed to share client confidential information with a trusted third party, ideally a guardian ad litem or somebody with a durable power of attorney. This is another subject that has been discussed for a full hour in CLE presentations. This is on page 14 of the written materials. I cite you to the August-September 2011 Oregon State Bar Bulletin issue, which has to do with what lawyers should know about their clients' capacity to make decisions. So I'm not going to go any further into this subject, but that article also has references if you need to go through those. And again, there is a CLE I attended through the Washington State Bar Association on this very subject. So if you want to know what that is, send me an email. Let's talk about safekeeping property. I'm talking about the property that belongs to your client, that came to you, or property that you created. So what exactly is the client's property when it comes to your files? Well, certainly it's anything the client sent you, whether that's a photograph or a USB disk or a hard drive or a piece of equipment. But what about work products? So you would think, I don't know, is work product mine or is it the client's? Well, I can tell you that there is an Oregon Formal Ethics Opinion 2005-125, which makes it very clear the client's file also includes the lawyer's notes or internal memoranda that may constitute attorney work product. So when the client requests a return of the file to you, you must return it and everything in it, with the exception that if you have an attorney lien, you do not have to return the file until the lien issue is resolved. If you do have to return the file and it is under circumstances that concern you, like you think maybe your client is going to make a claim against you, there's nothing wrong with making a full copy of the file. And I would suggest that you do that before you turn the original back over to the client. If you have to defend yourself against a claim that you neglected a matter or failed to communicate or otherwise didn't do the right job or not diligent, you're going to want to have that entire file in order to show what it was that you did do in representing your client. This also applies when lawyers change firms and take clients with them. Of course, you're the lawyer who leaves and takes a client, gets the client's consent, tells the former partners so-and-so client is coming with me, and the client here's the client's written authorization. You need to make sure that in the written authorization, the client is requesting that the client's entire file be sent to you, because without that written request, your old firm has no duty to send it to you, and in fact might be violating a duty if it gives up the file without the client's written authorization. So make sure that that is a part of the letter that you send if indeed you are leaving your firm and taking a client with you. Rule 1.15, IOLTA and trust account overdraft notification. This is the second one of the head scratcher rules, along with the if you're a judge, don't represent somebody that was in front of you rule. The money in the trust fund, including all the interest, belongs to the client. It's not your money. Don't take it. Don't mix it. Don't commingle it with your own funds. Why do we need a special rule for this? Well, it's to prevent the theft of funds, and unfortunately that has happened. So we need a rule about it. There is a research tip on this on pages 15 and 16 is where this is covered. Page 16, the research tip is to a 2008 article. Back in 2008, when the economy was taking a nosedive, the security of client funds was a real concern for the state bar, and former bar counsel Sylvia Stevens wrote an article called Trust Accounts and the FDIC Protecting Client Trust Funds in Uncertain Times. So that should be pretty straightforward. One thing you may or may not know is that if you are a mediator or an arbitrator, you have to have an IOLTA account, even if otherwise you are a retired attorney or some other kind of attorney, a contract attorney who doesn't necessarily need to have an IOLTA account because he or she does not handle client funds. Those deposits for mediation and arbitration are deemed client funds, and they need to go into an IOLTA account until such time as you earn them, and you earn them when you finish your work as a neutral. When I put up this image, I meant for it to be saying goodbye, but I realized it also could be saying hello, but in this case it's meant to represent declining or terminating your representation. I referred to this earlier in connection with I think it was client communications and not ditching your client. You need to take the right steps. There are some times when it's mandatory for you to terminate your representation. The most obvious of that would be if your license to practice law has been suspended or revoked and you're not allowed to represent clients. You must terminate your client relationship or face additional sanctions for that. But short of that, you can't leave a client hanging. You need to have court approval, and your termination of representation cannot have a material adverse effect on the client. I've given you a case called In Re Conduct of Costanza, and that is in your written materials, I believe on page 16. And in that case, the attorney failed to do 6 different things, some of which are violating other rules, but here's what not to do. He failed to allow his client sufficient time to employ another attorney. This is a lawsuit case. He failed to make any attempt to postpone the trial date. He did not file a notice of change or withdrawal as required by the Uniform Trial Court rules. He did not respond to opposing counsel's motion to dismiss and allowed the trial court to dismiss the action. He didn't respond to opposing counsel's proposed general judgment and cost bill, and he didn't communicate with his client about the general judgment and cost bill. The court found that this was not the right way to attempt to terminate representation and found the accused to have violated those rules. The Oregon State Bar published a two-part series in 2010 on the subject of declining or terminating representation. So if this is a subject that concerns you, please read those two issues and learn from them and do it the right way. Sale of law practice. This is Rule 1.17. Again, we have these rules because issues come up that involve client confidential information. How are you going to provide information to another lawyer about the value of your practice if you are not able to share some client confidential information, like maybe your attorney work product on the value of a case, or the value of 10 cases, or the value of 200 cases? Without sharing that information, it's very hard for the buyer to know whether whether he or she agrees with your selling price. So there are rules for a limited disclosure of certain confidential information. If this comes up, there is an ethics opinion on that, 2005-43. A lawyer may reveal information relating to the representation of a client to the extent a lawyer reasonably believes necessary in connection with the sale of a law practice. The ethics opinion particularly singles out estate planning attorneys who must make sure that client wills are returned to the clients or put in the safekeeping of successor counsel. Most of the estate planning attorneys I know prefer not to keep original wills and always send them home with the client with instructions that the client safekeep those wills. But back to the sale of the law practice, there are rules on this subject that have to do with ethics. If you find yourself in the position of selling your law practice, make sure you know what those are. Here's a happy picture. Some of these people could be prospective clients, and everybody is having a really good time. They're chatting. Somebody calls you over and says, "Hey, you're a lawyer. What do you think about this?" and starts giving you the lowdown on a car accident or a business transaction gone awry. Your red flag should go up. You should tell that person, "Gosh, I really only want to talk about business during business hours. Here's my card. Please call me at the office. Let's talk about the weather," or something more interesting. And the reason is that if you talk to someone about the possibility of being their lawyer, you may have entered into a confidential relationship with that person that even if you are not retained, you could be conflicted out from retaining another party in that same lawsuit. So don't mix cocktails and business, and recognize that if you do end up with a potential client or a prospective client, the former client rules apply to them. So you cannot represent someone adverse to the prospective client. And should you have had one drink already and forget that you already represent someone who is adverse, you might be resigning from that case and not getting the new client. So this is something that happens more on the East Coast. We should be very thankful that we don't have this problem, as far as I know, in Oregon. There is a New Jersey case, Unicorporation 19A3rd 966, that talked about the fact that this rule came up because there was a practice where lawyers were sending their clients to contact other lawyers for representation on a pretextual basis just to disqualify them. And this went up to the Advisory Committee on Professional Ethics, which created this rule to protect parties who have disclosed information to counsel during a preliminary discussion without requiring a court to strain to find that the preliminary discussion created a representation. So You have some duties to prospective clients, but the best thing to do is to only have client-lawyer relationships or discussions in a setting where you know exactly what you're doing and you're not just having a social chat. There are research tips on this. The Oregon State Bar had a February-March issue on the effective use of RPC 1.18. It makes for good reading. So let's say the unfortunate has happened and there is a claim made against you for violation of an ethics rule. You should know that the standard of proof, it will be clear and convincing evidence. You cannot be found to have violated an ethics rule merely because there is a preponderance of evidence against you. This is set out both in the bar rules of procedure and in a case that I cite on page 18. What about calling the bar for help? Can the bar help you answer an ethics question? Well, the answer is yes. Should you call the bar? You should consider the bar a resource, but you cannot rely on what the bar tells you to insulate you if you follow the bar's suggestion and it turns out badly. You do not have an attorney-client relationship with the bar. The best thing to do is to hire professional help, a lawyer who specializes in legal malpractice or ethics issues. But if you do call the bar, call them as a hypothetical. Just try to fudge the facts a little bit so it's not I did this, it's what if a lawyer did this, or someone I know did this, or no, don't say that, say what if a lawyer did this, because of course you do have a reporting requirement if there's another lawyer who has committed an ethics violation, but that's not the subject of today's discussion. So let's go back to calling the bar for help. This makes sense. This rule that you can't rely on the bar, this makes sense if you think about calling the bar for help the same way you think about going to the law library. If you go to the law library and you do your research, or you go on Westlaw and you do your research, you are the one who is analyzing the information given to you, and you are the one who is deciding how to act on that information. The bar is a resource. It is providing you with information. It is not making that decision for you. So yes, call the bar, but realize the consequences or potential consequences. I have also heard another time that I gave this presentation that bar counsel, having no attorney-client relationship with you, if you self-identify yourself as having committed a potential ethics violation, there's nothing to prevent the attorney at the bar from going on and reporting that to disciplinary counsel. So whether that happens or not, I'm not sure, but it's certainly not the kind of outcome you would want if you were just calling for help. And so what if there is clear and convincing evidence against the lawyer? How are sanctions determined? Well, the touchstone for this is protecting the public and the judicial system. Nobody wants this kind of bad behavior to happen in the first place, and certainly nobody wants to have it repeated. Nobody wants it to happen a second time. So deterring is one way of protecting the public and the judicial system. Disbarring, preventing it from happening at all, is another way. I would have to say that in general, the courts try not to disbar unless it's really egregious. They will consider the lawyer's mental state. Is the lawyer grieving? Is the lawyer impaired? They will consider whether an injury was caused. If there's no injury, should there be a sanction just for the behavior, even though nothing bad came of it? On the other hand, if there was a terrible injury, or you missed a statute of limitations and a claim was precluded, that could be pretty significant. The court will take aggravating and mitigating circumstances into consideration. Are you a brand new lawyer, or are you a seasoned veteran who should have known better? What was going on in your life? What was going on in the case? What was going on in the courtroom? What was going on with opposing counsel and your client? All of these will come into play in the court deciding what sanctions to apply. So we have come to the end of my presentation and my written materials. Again, thank you for listening all the way to the end. You have earned 1 ethics CLE credit. The program number for this, which is written down and along with the written instructions, is 6384*1. You're going to do your MCLE form and put that number down, send it in, and apply for credit. Also keep posted. I will be doing more of these video presentations and hope that they are an effective way for you to get your credits. Thanks.